Hi everybody, my name is Mark and this is my video presentation for Computer Ethics 4733. First, I just want to say thanks for watching this, and I hope it's not too boring. I try to make it as interesting as I can, so hopefully you guys feel the same. But the topic for my video today is patent law, specifically an area of patent law known as patent trolls. Now, some of you may have heard the term before, some of you may have never heard of it before, but don't worry, I've got lots of information here, so by the end of this video you'll be a patent troll expert. Specifically, what I'm going to focus on in my video today is why I feel that patent trolls are unethical, and I would even go as far as saying that I don't believe that they should be allowed to practice at all in the United States. Essentially, to me it comes off that they're just taking advantage of loopholes in the current patent law system that we have in place. So yeah, that's kind of a brief overview of what I'm going to be talking about today. So let's go ahead and get into it. So um, I know we've kind of discussed this throughout the video lectures and everything already, but the role of patent law in the United States seems like it should be pretty straightforward. An inventor has an idea that they feel is unique and novel, and that it would be eligible for patent protection. They work with an overpriced attorney to help file their paperwork with the Patent and Trademark Office. They file their application, and after even more time, more money, more revisions, hopefully eventually they will receive their shiny new patent. With that patent being issued to them, they now have protection of their intellectual property. Holding a patent gives them the ability to sue other parties who they feel may be infringing on their patent. Essentially, it gives them rights to that product or service or whatever it is that they've patented to hold for a certain amount of time. I think a key thing to keep in mind about the U.S. patent system is that there is the USPTO, United States Patent and Trademark Office. They issue patents, but they do not enforce them. It is up to the individual patent holder to enforce their patents in court. The government doesn't care if other people infringe on your patents. It's not really their problem. So, in theory, all of this sounds pretty straightforward, and it should be all very cut and dry, but as we all know, in anything to do with the law, it's not usually that easy in practice. And once you kind of do some digging into the patent system, you can see some of the glaring issues that we have with it. So, according to the United States Patent and Trademark Office, a patent is defined as the grant of a property right to the inventor issued by the USPTO. The right conferred by the patent grant is, in the language of the statute and of the grant itself, the right to exclude others from making, using, offering for sale, or selling the invention in the United States or importing the invention into the United States. And I got that off the USPTO's website. So it's obvious that patents are a very important method of protection to businesses, because without them, our the whole ecosystem would kind of be like the Wild West. Companies would be copying off each other. There would be a lack of innovation, a lack of incentive to innovate, and it would just be kind of a mess. So obviously, patents are incredibly important to the business ecosystem. So that's kind of a brief overview of the patent system and the role of patents. And now I'm going to go into a little bit about what a patent troll is. Unfortunately, as with everything, there are people who abuse the patent system of the United States. Patent trolls are essentially companies that they don't create any product or service. They exist only to gather portfolios of intellectual property, usually patents, and then enforce those patents in court. The technical term for these types of companies are non-practicing entities, or NPEs, as I may refer to them throughout this video. But they're kind of commonly known as patent trolls. And as I mentioned, these companies produce nothing of tangible benefit. All they do is purchase patent portfolios, usually from bankrupt companies, so they get these patents at a discounted rate, and they make their money by claiming patent infringement by other companies, taking them to court, settling, and licensing fees are kind of their main methods of generating revenue. So now that we have an idea of what a patent troll is at a high level, why are they bad? And I'm going to talk about why they are bad and unethical and should not be able to conduct business in this way. And I'm also going to talk a little bit about what the United States government is doing to try to curb the damage that patent trolls are causing. So patent trolls have grown at a really large rate. In June of 2013, the Executive Office of the President released a study called Patent Assertion and U.S. Innovation to specifically address damages caused by non-practicing entities. And one of the most powerful findings to come out of the study was that in only 2 years, the amount of suits brought by NPEs increased threefold, and it is estimated that they threatened over 100,000 suits in 2012 alone, which, that's an astronomical number. The study also found that 62% of all patent infringement suits filed in the U.S. were brought on by patent trolls. Now, if 62% of all patent infringement cases were brought on by trolls, then that's a very large amount, and shows that the number of legitimate cases is a much smaller percentage than they probably should be. These types of frivolous lawsuits brought on by NPEs, they're detrimental to obviously to the defendant company, but they're also detrimental to all taxpayers of this country. These types of frivolous suits, they waste the court's time, they waste attorneys' time, which all adds up into wasting taxpayers' money. These 62% of these cases, or as they said, 100,000, threatening over 100,000 suits. That's time that the court is not being able to spend on other things that courts should be doing. So it's detrimental to society as a whole. It's also detrimental to the end users or consumers of the defendant's products or services, because legal costs are very high. The cost to litigate these cases are extremely high. So every dollar that the defendant is spending on litigation costs is another dollar that they are unable to spend on innovating their products or lowering their product or service prices. Many companies, due to these cases, they have to increase their costs. So it's very detrimental to the end consumers. Now, this study speculated that there were two main reasons for the increase in suits brought on by NPEs. The first reason that they speculated on was due to the increased number of computer and communications patents, which, due to the broader nature of them, make them much easier to abuse. It was found that software patents are nearly 5 times as likely to be in a lawsuit versus something like a chemical patent. The second theory that they have is that since patent trolls do not actually produce anything, they cannot be countersued. So what happens when actual patent infringement happens is someone will feel that their patent is being infringed upon, they will sue said company, and then the other company will countersue them for whatever. And so then, that lowers the reason to want to go to court, because companies don't like litigation. They don't want to have to countersue and all that. That increases costs. But since patent trolls cannot be countersued, well, then that's an incentive for them to sue. Makes it easier for them. Now, patent trolls are also especially damaging to smaller companies because of the high cost of litigation. As I mentioned, litigation is expensive, so NPEs also do not like to go to court. They would much rather send a cease and desist letter or a letter threatening to take someone to court and have that defendant reach a settlement with them, whether it be a lump sum of money or licensing fees. So it's a lot easier for patent trolls to kind of bully smaller companies. When you think about it, they're not going to try to try to go up against a Google or an Apple or a Samsung, somebody that they know has more resources than them, will probably not cave to their demands. They have Google, Apple, Samsung, companies like that. They have extremely powerful, attorneys backing them. So yeah, the MPs don't want to mess with them. They like to prefer to kind of bully smaller companies, and it makes it a lot easier for them to get what they want. So yeah, they definitely target smaller businesses more often. And then just to kind of throw in as a side note here, at this point you may be kind of wondering, well, what are other countries and around the world doing to combat these practices? And the fact is that most countries don't have as bad of an issue with patent trolls as the United States does. For example, in Europe, they follow a model of the loser pays cost method. So what that means is that when you take someone to court, if you sue them, the loser pays both sides' attorney's fees. Whereas in the United States, each side pays their own fees regardless of the outcome. So this has significantly cut down on the amount of patent infringement cases in Europe, because patent trolls are not going to take that risk of having to pay both sides' attorney's fees. This another interesting thing that came out of the study was that they gave a couple examples of some of the tactics used by NPEs, and just to kind of illustrate how kind of out there some of them get. And so I'm just going to briefly discuss what one of these examples are. So the example listed in the study talked about a certain unnamed NPE that sent out letters to hundreds of small businesses claiming infringement of patents if the company had any document scanners on their network. Now, obviously, most companies have some sort of document scanner, so they would, think that you're infringing their patent. In these letters, they demanded $1,000 per employee for a license. There were no specific details within the letter to give any actual evidence as to why they were led to believe that any patents were being infringed upon. So very vague. And again, here they targeted small businesses. But actually, in this particular case, the NPE was sued by the state of Vermont for, quote, unfair and deceptive practices, alleging that the letters were targeted to businesses and nonprofits unlikely to be familiar with patent law, and that they shifted the entire burden of the pre-suit investigation onto the small businesses. So this is just one example of kind of the ridiculous tactics that MPs use to try to take advantage of other businesses. So now that I've talked a little bit about what I think are the unethical practices by NPEs, I want to talk about, throw out some hard numbers about what, how much dollar amounts these MPEs are actually causing. So again, keep in mind here that we're not really talking about large Apple and Google and Samsung type companies. So these types of numbers really hurt small businesses. So in a recent study done by Boston University, fairly recent, this was actually back in 2011, but they found that the cost of actions by NPEs amounted to $29 billion. So that was back in 2011. 8 years later, you can only imagine probably how high it is now. They showed that was an increase of 400% since 2005. So in 6 years, from 2005 to 2011, it increased 400%. So it's probably safe to say that it's increased another couple 100%. It's estimated that on a per case basis, the litigation costs alone ranged from the low end of $650,000 to upwards of $5 million. And as I mentioned earlier, every dollar spent on these suits are money that are not being spent on product innovation, so it really hurts everyone. It is estimated that between 2007 and 2011, cases brought on by patent trolls caused a value loss of over $300 billion. And what I found most interesting about that is that half of the companies had less than $100 million in annual revenue. So that just really shows that they target smaller businesses. Um, and as I talk about NPEs and what they do and everything, it's very important to keep in the back of your mind too that what is the purpose of the patent system? Um, the purpose of the patent system is it exists to protect, to allow a business to create an innovation and profit off of that innovation and stop others from copying that. So if you think about just a general example of, let's say Ford was infringing on a patent from Toyota, Toyota is fully within their right to sue them because that's actively costing them money. If they came up with some new engine innovation that increased gas mileage and Ford copied that, well, that there's a tangible value loss there. But in the case of an MPE, well, what is the value loss? And I think this is a very important question to whether or not MPEs should be allowed to exist. And there really is no value loss because they don't produce anything. So by somebody infringing on their patents, they're not out anything. All they do is use that additional revenue to purchase more patents and sue more people. So really, at a high level, they produce nothing of value to society as a whole. They're really kind of just a leech on the patent system. So now that I've kind of discussed some of the damages caused by patent trolls, what is being done to fix the situation? The federal government has taken steps to try to curb the power of patent trolls. President Obama made a strong stand against patent trolls by issuing a total of 5 executive orders aimed at curbing their unethical practices. One of the orders will force the USPTO to require that patent holding companies disclose who stands to benefit from a lawsuit. Also, the suing party will have to identify the ultimate patent holder for each application and assigned patent. So these are, some of the steps that the U.S. government has taken. One other quick thing that I wanted to mention is that universities are also known as non-practicing entities. So I think it's important that there would be a delineation of maybe for-profit businesses versus non-profit businesses when it comes to categorizing NPEs. Universities aren't in it to make a profit. Many schools have very large research funds. They'll usually have their own tech transfer offices, which is in charge of patenting or trademarking their technologies, and then they'll license it out or sell it, and then use the money that they receive to put back into their research fund. So it's important to realize that not all NPEs are bad. Schools are obviously trying to do it for the greater good and not just make a profit. So this is kind of concludes my presentation on patent trolls, the damages they cause, why they're bad for society as a whole. So just, real quick, I guess my personal thoughts are that, as I stated at the beginning, I think that NPEs are unethical. I think it's essentially a legalized form of extortion. I think it's an abuse of the patent system. They, as I've shown, they provide nothing of value. They hurt businesses, they hurt consumers, they hurt taxpayers. They really hurt society as a whole, to no benefit. So, in my opinion, for-profit NPEs should not be allowed to exist at all. And so, some of the questions I guess I would pose for you guys is, what are your thoughts on NPEs? Do you feel that they're unethical? Do you feel that they should even be legally allowed to practice in the United States? And then finally, I guess, what are some of your thoughts on what could the government or we do as consumers to try to curb the damage that they cause, and what actions do you think should be taken? So I just want to thank everyone for watching and have a good day.